This is case number 10-2619. This is Palisade Collections versus Natasha Johnson. The matter is before the court on objections to the filing of a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case by default on the 19th of April of 2010 for $12,607. The record should reflect further that that judgment was renewed at a subsequent time, and that the that renewal date looks like 2020, February 7, 2020. And this is an effort to collect on that same judgment. All right, your appearance for Palisade, please.
Yes, Your Honor. David Bader representing Palisades.
All right, your P number, if you will, for the record, counsel.
P67307.
All right, thank you, counsel. Good morning to you. Do I have Natasha Johnson on this Zoom? Say something if you're there.
Yes, I'm here.
All right, good morning to you, Ms. Johnson. I do see, and I've reviewed your objections to the written garnishment. You said I never received notification of the reinstatement. That is typically done ex parte, meaning that you would not get a notification that the judgment is renewed, but it was in fact renewed back in 2007, and that does not really provide a valid objection on this particular claim that's being brought here. So what objective do you wish to achieve, ma'am, by filing the objection? Tell me what outcome you're trying to do.
The paperwork that I received when I came down said that it was for $12,601, and then this one says that there's a $31,000 balance due and $8,900 had already been collected. And if I owe $12,089 has already been collected, should my balance be $4,000 and not $31,000?
Well, you have an interest problem for sure, and if the judgment has not been paid in the over a substantial period of time, you have judgment interest yet accruing on it. So it would not certainly be $4,000, but you're saying that you receive something in the nature of $30,000. Let me hear from counsel on this matter, sir.
Yes, Your Honor. There were numerous payments made by the consumer. However, it's accruing interest per the judgment at 13%. And because of that, it looks like it's accruing interest approximately $12 a day currently. And that's how we got here on such an old judgment.
Yeah, that's the kind of problem that I anticipated. I mean, so ma'am, what type of strike it? Are there some payments being made now voluntarily? And if so, why the garnishment? What's going on here, counsel? Give me some update.
There are no payments being made now. When the last garnishment was happening, I thought that this account had been settled because I had paid over half from the conversations that we had. But okay, now I'm getting this, that it was started back in 2020. And I never got any notification about the 2020 reinstatement.
Okay, my question wasn't to you, but I appreciate the updated information that you provided. The problem is that you still have an outstanding judgment, of course, and that unfortunately, that's one of those judgments where a high interest rate is accruing. And so even as you're paying, you basically, or have been paying or have paid in the past, any periods where there was not payments being made, and even while payments were being made, interest was still accruing on this judgment. And that's how problematic this gets sometimes, especially when you have a judgment that's as old as this is, and you have many years of interest accruing. That's the problem. Counsel, I was trying to get an update from you, sir, regarding whether or not there was payments. Ms. Johnson has advised me that there are not any payments being made at this time. And now I understand why there would be the effort, the garnishment that's released here. All right, so Ms. Johnson, are you working for National Realty Center? Is that why they're being garnished in this regard?
Correct.
All right. And has any money been taken out of your check?
Yes.
All right. How much is taken off? What do you get paid every other week or every week? Tell me about that.
It's contractual work, so I only get paid when I have a closing
Okay,
as a real
gotcha.
estate agent. Yes.
As a real estate agent, gotcha, man.
Mm.
All right, so recently, how much money was garnished the last time that you were garnished?
There was one for $925, and then there was another one for $1,460
Okay. And those two garnishments occurred over the last month or over what period?
over the last month.
Over the last month. Okay, so you basically
Yeah.
been hit for about 25, 2,400 over the last month. Gotcha. Okay, counsel, is there any chance that both sides can talk about trying to cap this somewhere and seeing if you can reach an agreement regarding payment? Because obviously the defendant has made some effort to pay, although slottily, because this has been a long time. But this is obviously going in the wrong direction. I mean, you have, it was a significant judgment from the beginning at 12,000. Now, she believes approximately 6,000 being paid. The interest has taken it up to well over 20, probably $30,000. I'd like for the two of you to take a moment and break our room to see if there is some cap number where maybe the parties can find a way to work this out, given it's been a long time and she has made some effort to pay. And recently, looks like $2,300 has been settled 100%. So go ahead, Counselor. I have like 3 questions. So go ahead.
Yeah,
Mr.
Judge, that I'm more than willing to do that, but can I check in with another courtroom and come back to this?
Sure, you can do that. Miss Johnson, you got a moment to hold on for a bit, and he'll come back and then get a chance to talk about this and see if we can reach some kind of way to resolve this so that you can have some certainty and cap this off and figure out a way to get it done. That makes sense to you, ma'am?
Yes, sir.
All right, so I'm going to stand down on your file for a moment, Ms. Johnson. I'll come back to it shortly. Mr. Baker, you can go ahead and do what you have to do. Come on back in here.
Thank you, Judge.
All right, thank you, Ms. Johnson.
Thank you.
All right, the court now calls case number 21-171176. This is Bright Financial Services LLC versus Jenna Kentika McGee, last name McGee. The matter is before the court on the filing of objections to a writ of garnishment regarding the Michigan Department of Treasury record should reflect in this matter that there was a judgment that was entered in this matter. That judgment was entered by default on the 3rd of August of 2022. The total judgment amount is $7,297.61. And I do see 2 objections to garnishment. One relates to Amazon Fulfillment Center. The other relates to Michigan Department of Treasury. In both objections, the defendant states, I have not lived in home since June 1, 2019. And then she provides attachments in that regard. All right, counsel, your appearance at this time.
Good morning, Your Honor. Robert Goodman, P55670, appearing on behalf of the plaintiff.
Thank you, counsel, and good morning to you, sir. All right, I'm looking now for Ms. McGee. Say something if you're here, ma'am.
I'm here.
All right. All right. Thank you, Ms. McGee. Good morning to you. I see on the documents that you're indicating McCullen now. Has there in fact been a change as it relates to your name?
Yes, I got a divorce back in February of this year.
All right. I thought maybe you picked up a name. I see you dropped one. All right. I knew something had happened here. All right.
Yes.
So, ma'am, you've in looking at your objections here, you indicate issues regarding the change of address or that you were not living at a certain address. Those are not issues that can be properly raised as it relates to the writ of garnishment. If you are going to file something, you have the right at law to attack the underlying judgment by filing something in that regard. But this is post-judgment. That means that there is already a judgment in place, and the defendant, the plaintiff is attempting to collect on that judgment. If you believe that there is something improper about that judgment, you would have to attack the underlying judgment, because the law doesn't allow you to attack the underlying judgment in the post-judgment proceedings. So it looks like your garnishment is talking about not living at a certain location, apparently on Baylor Street, correct, ma'am?
Yes, sir.
All right, so what has happened here is that there is a document contained in the court's file that's called a proof of service. And that proof of service is what gave rise to the ultimately to the default judgment. The proof of service provides that the document was served personally on Baylor Street in December 2021. And that's the basis upon which ultimately a judgment was entered. If you believe that there is something wrong about that, you have the right to file motions to address that issue. But with you can't address that issue today. You have to attack that and not the post-judgment matter. And your items are attacking the post-judgment. I'm going to come to you in a moment, ma'am. And so go ahead, counsel. Anything you wish to say, and then I'm coming to Ms. McGee, Ms.
No, Your Honor, nothing other than we filed a response indicating that her objections didn't really fall into any of the categories identified in MCR 3101 K1. And as far as, there's a proof of service that she was personally served. We spoke to Ms. McGee several times before the lawsuit. She confirmed her address. And so I don't believe we have an issue regarding service either. I'm happy to speak with her in a chat and get her on a payment plan or something. But I don't believe that she's raised any valid objections.
So, thank you, counsel. You're going to have to mute yourself there. Okay, you have to stay on mute until I come to your case. Thank you. All right, Ms. McGee, you understood what I said to you, ma'am?
You basically said that there's nothing that I can basically do about it.
No, that's not what I said. I said I said that in order for you to raise the issue that you seem to be raising, and that is an issue of service, you have to file a different type of motion because this is post judgment.
Okay.
So you'd have to file a different type of motion. But let me try to drill down on what your issue is, because you might be able to get some type of payment set up where you don't have to stay under the garnishment while you are filing other motions and what have you. So let me ask you about that. I know that the Department of Treasury garnishment, that relates to an effort to collect anything that you may have coming from the Michigan Department of Treasury. Are you expecting an income tax return? Do you usually get an income tax return from the state?
Yes, I do. Yes, I do.
What range is that usually in terms of dollar amount, you know?
I'm not sure this year because I've actually been off of work for the last year and a half because I just had spinal surgery last year in September. So I've been off on workman's comp.
Okay.
And I stopped getting workman's comp back in June of this year.
All right. Yeah. All right. So it seems like on that one, that particular one, there's not really a valid objection to that one, and I'll have to find the objections invalid. And if there's any money that comes through the state, then that will be released towards the payment of the judgment on this matter. Let's talk about the garnishment as it relates to your employment, and that's at Amazon. Is that correct?
Yes, but I'm still not back to work.
You're still not back to work? Okay.
No.
All right, so about this money that they're claiming that you owe, anything that you want to say about that? And because if for some reason you file a motion, if for some reason the judgment is set aside, if ultimately this is a debt that you owe, then you still come full circle and have to deal with addressing the debt situation. So it doesn't seem to me that there is a real issue here as it relates to the writ of garnishment. If I allow the garnishment to stay in place, they still don't get anything because you're not back to work. But if you wanted to figure out a way forward in terms of maybe reaching a payment agreement or something, then that could stop some of this while you're in the process of figuring out if you want to challenge the underlying judgment. So if you set up some type of monthly payment, that prevents your wages from being gone. is what I would say.
Okay.
So,
I
so
just,
tell me.
I
Mr.
just had, I just had the question of, I was told that when you go through something like this and they supposed to come get the car and try to sell the car and then you pay the difference between it, is that necessarily true?
Uh, that's not necessarily something that has to be done, but oftentimes when there is a pursuit after an asset, and suing on an asset, many times the vehicle is seized and then sold, and then the difference, you pay a deficiency balance. But that doesn't mean that an entity that is suing, that they have to take the property back. They can simply sue on the contract. And it seems that that is what is being done here. Let me hear from Mr. Goodman if anything I'm saying that might not be on track with what this client. That would be, sir.
Well, Judge, our client certainly has a duty to mitigate their damages. In this particular case, the vehicle was either at a tow yard or at a mechanic's place. I believe it had I was reading through the notes in preparation for the hearing today. I believe it had either an engine blown or a transmission blown, and the value of the vehicle was less than what it would cost to take it out of either the mechanic's yard or the impound yard. And so there was a business decision made to not pick up that vehicle because it would have not inured to her benefit. So it didn't make sense, from a mitigation standpoint to grab the vehicle.
Yeah, and not to piggyback on anything that Mr. Goodman says. I mean, he has one side of this, but I did in the process of running through this, I did fail to mention the mitigation of damages requirement. And mitigation of damages simply deals with the fact that if they're suing you and there's a way to try and lower the amount, that is a reasonable approach that they would be required to do that. This situation, and most times companies are absolutely apt to do that, unless the asset has become so depreciated or engine is blown or some other significant damage to the vehicle, that then they conclude that it's more expensive to try and recover the vehicle than it is to just go forward with the lawsuit. That seems like what happened here. Although, again, you can file a motion if you wish regarding the judgment itself and challenge that, and the court would have to conduct the hearing and file a proper motion in that regard. Again, to drill down on the issue, basically, the point that I was raising with you is that if this is money that you think that you may owe, you might want to think about a reasonable approach at trying to keep this from becoming a surprise and manage it by setting up some type of payment arrangement. Because as long as there's nothing out, if there's a judgment in place, and there's nothing in place to try and tackle that, then this can surprise you in many different ways. It could result in garnishment of bank accounts and things along those lines. But oftentimes, if you have a payment arrangement in place, oftentimes the other side will not exercise other forms of garnishment. Now, they don't have to stop garnishing like bank accounts, but usually if you've got a payment plan set up, most of the times they'll go with the payment plan, not go after other things. So that's why I raised that issue. As it relates to the garnishment, it does not seem that it's affecting you or impacting you in a way. So, and I don't see any basis to set it aside at this time. What I would recommend is that if Mr. Goodman has a moment, you have a moment, I can put the two of you in a breakout room and maybe talk about what to do in the interim as far as some type of partial payment. Does that make sense to you, Ms. McCullum?
Yes.
Sounds
Let me
good.
try that. And let's see if we can get something worked out there. So I'm going to give you a notification to go to breakout room number 1. And I'll stand by on the other side.
Now, do you want us to check back with you after, or are we through with the motion?
Yeah, if you'll just check back in because I don't think I have a basis to do anything other but then deny this writ of garnishment. But if you guys get something worked out, maybe I'll hold down on this for just a moment. All right.
Okay.
So come back in and just let me know one way or the other. Okay.
Thank,
So go ahead
thank you,
and
Judge.
break up. And I'll stand down for a moment.
Thank you.
So you got your notification. All right. All right, the court now calls case number. Judge, I wanted to let you know that. Oh, sure. So. There we go. 1 second, Counsel.
That there's a Shayna Stenson is on here. It's not on the docket, but it do say the computer is scheduled.
Is it scheduled today?
Yeah, it's ending 279.
I'll call it. This is case number 22-186-225. This is Automobile Club of Michigan versus Jonathan Washington and Kevin Campbell. The matter is before the court. Looks like it's set on for a pretrial conference. Counsel, your appearance for the plaintiff in this matter.
Yes, thank you, Your Honor. Dylan White, P80755 for Auto Club of Michigan. It looks like we've also submitted a motion for summary disposition on this date as well, Your Honor.
And I do see, I do see the motion for summary disposition contained within the court's file. All right. Do I have Jonathan Washington or Kevin Campbell on the Zoom?
Yes, sir. Kevin.
Yes,
Campbell.
sir. I'm here.
All right, I see Kevin Campbell. I also see Mr. Jonathan Washington. I do see that both individuals filed answers to their complaint. Let's see one more thing. Yeah, and I see that the court did set up a scheduling order, and I allowed today's date as the pretrial and also for the filing of motions to be set for hearing. All right, so have you received a copy of the motion regarding this matter, Mr. Washington?
I don't think I received a copy.
What about you, Mr. Campbell?
No, sir. I haven't received any copy.
Oh, the two of you live on Burden Street, Brighton?
I live on Brighton, yes, sir.
Who's that lives on Brighton?
Campbell. That's my address.
All right, let's see. Here, Mr. Counsel in this matter provided. All right, so Counsel, you filed your motion. It got to the court on the 31st of October. I know that is plenty of time based upon the court's scheduling order that allows for hearing of motions on today's date. I believe Mr. Campbell says he lives at the Brighton address. Mr. Washington says that he does not. But when they filed their answer, both of them provided the same address. So, yeah, you both provide the same address when you file the answers to your complaint. So what's going on here, Mr. Washington?
It was I think the reason why I signed the same address was because I got an apartment here in Southfield, but I wasn't yet inside the apartment, so I put it down as 8383 Brighton, but I no longer live there anymore.
Oh, well, you're still responsible for whatever goes to the other address, but that's the only address you get. All right, Mr. Bryden, strike that out. Counsel, so when did you send these out? Because both of them were saying that they never received a motion for summary disposition.
So it looks like our proof of service is saying October 25th, Your Honor. First class mail to the Brighton Street address.
So now, okay, Mr. Campbell. So, Mr. Campbell, you get mail there on a regular basis, and you say you didn't get this mail?
Yes, sir. If their mail was the one that I had to sign a signature for, I went up to the post office and they said, I guess because I wasn't able to get to the post office, within a timely manner. They sent the mail back or something like that. So I don't know if it was them or not, or if it was somebody else, but I didn't receive anything. I received a letter on my door saying that I wasn't available. I need to get to the post office because of my work schedule. I wasn't able to get to the post office, and I guess in a timely manner or whatever. But I don't know if that's their mail or not. So
Yeah, well, this one wasn't sent through the post office. This was sent through ordinary mail, correct, counsel?
Yeah, it looks like first class mail to the address listed there.
well, I never got.
Well, I sent you mail to Bryden Street to give you today's court date. You got that, didn't you?
Yes, sir, I did.
All right. So, counsel, let me hear. Tell me what this motion is about, sir.
Yes, Your Honor. Plaintiff's motion for summary disposition. On around October 18th, 2020, plaintiff's insured was involved in a motor vehicle accident with defendant Campbell's automobile, which was driven by defendant Washington, when defendant Washington did an illegal left turn in front of plaintiff's insured, causing the accident. At the time of the accident, defendant's vehicle did not have no-fault insurance as required under Michigan law to cover defendant Washington. As a result of making defendant Washington liable, plaintiff's insured suffered damages in the amount of $5,998.86. This lawsuit was brought after some attempts to get reimbursement or proof of insurance coverage. Both answers were filed from both defendants on, looks like June 28th, 2022. Defendant Washington alleges he was at fault. He was not at fault, and the vehicle had insurance, while defendant Campbell alleges he was not the driver and he had insurance on the vehicle. The police report shows that defendant Washington's fault was corroborated by a witness at the scene, and he was also cited for failure to yield before performing that maneuver. As of this date, we've failed to receive any proof of insurance coverage, and indeed, looks like defendant Campbell's insurance carrier sent a denial of coverage letter as to defendant Washington, showing he was not a covered driver at the time. In addition, discovery requests were sent to both defendants, and no responses have been received. Defendants have failed to state a valid defense. Defendants have failed to answer this motion for summary disposition, and there seems to be no genuine issue of any material fact with regards to either defendant. Defendant Washington is liable under Michigan law for not being covered by insurance, and defendant Campbell is liable under Michigan law under the owner's liability statute. That's it, Your Honor.
Yeah, so the nature of the motion in this matter is asserting the ideal that there is no defense to the claim, where there is the operation of a uninsured vehicle, and where the owner of that vehicle allowed someone to operate the vehicle, and the vehicle was involved in an accident where the documents from that scene indicate that the operator was at fault in the automobile accident. So that's the nature of the motion in this matter. Now, the parties defendants indicate that they have not received it. Is it your intent or your desire that you wish to file some type of response to that motion? Because what counsel is saying to the court, what he's arguing by the filing of his documents, is that there's no genuine material issue of fact. There's no defense to the claim, and that therefore they should be allowed a judgment without delay, and that judgment should apply to both individuals, because one was the owner allowing someone to operate the motor vehicle, and the other was operating the motor vehicle, and that in either case there was no insurance involved. That's the argument that's being made. Mr. Campbell, what do you want to do about that? What do you have to say about that?
I don't understand nothing y'all just said. I'm just being honest. I kind of got an idea, but I don't know what was being said. All I know is I wasn't driving. I had insurance on the vehicle. And I don't know who to send, what to file, what motion, any address or whatever. Matter of fact, the company that I was insured with, they are no longer operating in the state of Michigan. So that's just been a hassle within itself to talk to them. And so I don't know. I don't
Yeah,
have.
see, well, and that's a problem, Mr. Campbell, because see, if they're not covering you, it falls back on you. Yeah, that's the problem. If for some reason they will not cover this, it falls back on. And that's the situation that you're running into here. So if you got insurance coverage, then this is a non-issue for you. But if you had coverage and they're not willing to cover it, or they stop operating, then unfortunately the burden falls on you. Insurance is just to cover you, and if they don't cover you, then it comes back to you. And that seems to be the challenge there. Let me hear from Mr. Campbell, I believe. Yes, Mr. Campbell, anything?
I was Mr. Campbell that was just talking. You want
I'm
Mr.
sorry,
Washington?
Mr. Washington. Mr. Washington.
Oh, yeah.
And Mr. Washington, the allegation is that you were operating a motor vehicle. Anything you want to tell me?
So so as far as the $6,000 that I do have to pay, you said that it's me and Mr. Campbell's, it's like under me and Mr. Campbell to pay the $6,000, or you saying it's really me that I have to pay the $6,000 in damages?
No, because it was called the Michigan Owner's Liability Statute, the owner of a vehicle is responsible for, the owner of the vehicle is responsible for damages caused by the operator. And the operator is responsible for damages caused. So it's joint liability. Both of you will be liable because of the way the statute reads. So if I allow you to operate my motor vehicle, if you stole it from me, that's a little different. But if I allow you to operate my motor vehicle and you accident, then you're responsible. If you're at fault, you're responsible. But I'm responsible as well under the Michigan Civil Liability Act. So that's what's going on here. That's why Mr. Campbell is being sued. He's being sued because he owns the vehicle. And he's not saying that you stole the vehicle from him, or that you snatched it out, snatched the keys and drove away. Saying that it seems that you have permission to drive his vehicle, so he's liable for whatever you're liable for. That's the long and short. And the question is whether or not either of you have anything to raise as a defense in this matter. And from reading the answers and looking at the various items here, I'm not seeing a defense. Usually in these situations, there's some insurance somewhere, and so it gets worked out that way. Without insurance being involved, then it comes back to the individuals, and that's what seems to be happening. That's what seems to be going on. Anything else anybody wanted to tell me at this time? I just wanted to make it clear. I know Mr. Campbell was saying he wasn't getting all of this. Mr. Campbell, you're here because you own that vehicle, because your name is on the title. That's the problem. That's the only reason you're here. You didn't have to drive. All you had to do was own.
Oh, okay. But so this is considered post judgment because
No, this is a motion. This is a motion for entry of judgment. That's what this is. Council is requesting entry of judgment now based on a procedure called summary disposition. And the reason he's asking for an entry of that order of judgment is because he is asserting that there is not a defense to this, that there's nothing, no real challenge that you have to this, other than the fact that you don't like that it happened and that you don't have insurance.
The reason why I asked was because as I looked at the pictures that they sent, you know what I'm saying, was that even brought up, or that judgment is already gone? Like they is already sealed that he's at fault. And that's it. That's because I'm looking at the pictures. I'm like, there's no way. And I seen the damages on the car. I'm like, there's no way you could have been at fault. But you know what I'm saying? I don't know. Like I wasn't there. So I was actually out of town. So
yeah, well, it seems to be that it seems to be that where law enforcement and a witness assess fault in this matter, and issue the citation, that is going to be difficult to overcome those kind of compelling issues as to who is at fault. And then there are some other issues involved there. I mean, if you think that there is something that you wish to raise, and that you think that you have something to challenge the motion for summary disposition with, then you need to tell me that. I'm not seeing anything, to be honest with you. And,
Well, I was saying, like, cause sir, I'm not trying to be a jerk or nothing. I just don't know what's going on. Besides, I am the owner of the vehicle. I saw the picture that was sent about the accident. I saw the actual vehicle. And I'm like, is this about the actual accident, or is this about the police said something and we didn't have our chance to say, hey, no, that's not how the story went. And well, police final word, that's it, that's all. And y'all owe us $6,000, because the way the accident looked, it didn't look like that to me. Like, I've been driving for a long time like yourself, and I know to hit my brakes or something, slow down or something, but it looked like somebody, he was hit on the passenger side at the tail end of the rear bumper. That means he was already cleared. You know what I'm saying? Either you didn't slow down, you weren't paying attention, or you just went on and hit your gas and hit the car. And I know it totaled out my car, but I don't know if this is the judgment that we are handling right now, or is this just saying, hey, police said it's it, and that's final word. You don't have no say-so in court. And one of y'all got to pay us $6,000. That's what I'm trying to get to.
Okay, Mr. Gamble, yeah, you didn't understand anything you told me, but now you understand everything. And let me say this to you. Don't play victim. I mean, because, when you talk about, well, we don't have nothing to say and we just have to pay $6,000. Now stop. You know what this is about. You know that you owned a vehicle. If you had insurance on, insurance would cover whatever they cover. And you know that this gentleman was in an automobile accident. Then in addition to that, you also know that you had the right to file answers and so on and so forth. And you know that at the accident, disinterested people show up to the accident and say that this is the way that it happened. Accident reconstruction is done. A police report is issued that says that this is the way it looks like it occurred. Citations are issued in that regard. I mean, the notion that we just show up and they tell us we got to pay $6,000. No. Come on. That's big. I know you're smart, but be smarter than that. I mean, that's not what this case is about. This case is about the fact that, unfortunately, Mr. Washington had an accident. You weren't there. You didn't see the accident. I wasn't there. I didn't see the accident. But what we do know is that Mr. Washington had an accident. And when he had an accident, the vehicle was not covered by insurance. And the people that saw the accident, a witness says that he did something that he wasn't supposed to do. The reconstruction of the accident says that he was in the intersection at a time that he shouldn't be in the intersection. He was issued a citation that looks like he's at fault in the accident. That's what the case looks like. Now, like I said, it seems that the motion may be on all fours. There's not a defense here. But if you or Mr. Washington have something that you want to file that you believe will show that there is some type of defense in this case, then I'm perfectly willing to delay this for a time to allow for that. But again, I'm as a judge of 30 years, just measly 30 years, and trying to take some time to pay attention to stuff and look at the issues, and to be honest with people, I'm trying to tell you what the case looks like. It is what it is. But if you think that you have some defense that you wish to raise to this, then I'll give you a little bit more time to raise that. But I'm not seeing it based upon the answers that was filed, based upon the police report, based upon the reconstruction, if you will, of how the accident may have occurred. I'm just not seeing it there. And when that is not there pre-trial, there's a way for a party to ask the court for a judgment saying that, Judge, this is not getting any better. This is the case. The facts are what they are. The case is laid out the way that the case is laid out, and we're entitled to judgment as a matter of law. This is not something that attorneys make up. There are certain statutes and court rules that says that if the facts and the circumstances exist a certain way, then you may be entitled to judgment before going to trial. That doesn't mean that persons do not get a chance to be heard. When a motion is filed, you get a chance to respond to that motion. You come to court, there's a hearing on that motion. You get a chance to respond to that hearing on that motion. So all of that is responding to information that's being brought before court. It's just that when I consider all of this, I don't see where there is a legal defense that can be brought to the claim. And under the court rules, where there's not a legal defense, then the plaintiff would be entitled to judgment in a summary way. And that's what this hearing is about today. So what do you want to do? I know obviously the key person involved in the accident was Mr. Washington, but Mr. Campbell, you get dragged into it because your name is on the title. That's you don't have to do anything else. All you have to do is have your name on the title, and you get to be a part of it. If you had a sister and her name was on that title too, then it would be Mr. Washington being sued, Mr. Campbell, and your sister, because everybody on that title is responsible as under the Michigan Civil Liability Act for whatever Mr. Washington is responsible for. Mr. Campbell and anybody else on the title would be responsible for that as well. That's how the law works on this particular situation. Okay, so tell me, do you want to file a written response? Or do you wish to file any other item before the court? Because if I have to make a decision on this today, it looks like there's not a valid defense to this claim. So go ahead. I don't want you to want to talk to me. Go ahead.
Hey, Your Honor. This is Jonathan Washington, his son. I just want to say that my father wasn't in the accident, so he don't really know what happened. And basically, I was just saying what was told to him and what he see from the pictures. I wasn't at fault in the accident. You know what I'm saying? But I understand that my name wasn't on the insurance, and I understand the whole case. You understand what I'm saying? So I get it, and I know that basically I couldn't win in this because I don't have insurance in my name. And right now it's just a lesson learned, and I'm willing to do payments or whatever it is. But yeah, I didn't know that the damages were $5,000. That's also a shock to me. And at the time I was in college, so it really was like, you know, I gotta pull it out from somewhere. But if we can figure out a deal, then it'll be fine. I don't want any trouble or whatever, but I wouldn't know how to go against this because I have no insurance on the car. So whatever we got to do.
Well, that's a reasonable statement, and I think you nailed some things on the head. And again, it's not that you have not challenged this appropriately. I think that you raised the issues that you can, and your father has raised. I don't know, Mr. Campbell is your father, correct?
Yeah, he's my father.
All right, and he's raised the issues. He's raised the issues correctly and adequately as well. And unfortunately, what I'm indicating to you is that it doesn't appear that there is a defense to the claim, and that because there's not a defense to the claim, then you end up with this situation where you got to deal with something that the insurance would have dealt with before. Because even under these circumstances, I think that what would have happened if there had been insurance, then Mr. White's client, the attorney's client, will be looking to recover from your insurance. They'd be looking to get a contribution or a reimbursement from your insurance company. The only reason that this gets to be real personal is because you don't have the insurance in place that will cover it. So it'd be the same thing. It would be either you paying or your insurance paying on your behalf. And because there's no insurance, the insurance is not going to pay on your behalf, and that's how you end up with this type of situation. I'm gonna go to another matter, so on and so forth. Obviously, I feel a little bit personal to this because I have 6 kids, and I've sent 4 of them to college, and they've driven vehicles with my name. They've driven vehicles with my name and my insurance, and in 2 instances, I didn't even go to insurance. I just, came out of pocket to pay for stuff. But, it is what it is. That's a part of the challenge in all of the courses when they were in college. So I get Mr. Campbell. I know how that works out. Do I know too well? But yeah, that's seemingly where it ends up at. So here's what I'm going to do. before I make a final determination of this, I think that it might be worth a moment to talk about it a little bit. So see if you can come to a way of resolving it together with some type of payment plan that may work this out if you can do that. So I'm going to send you a notification to a breakout room. Council's going to be there. You know where the court's thoughts are about this, because I've tried to take a little time to really pay attention and read through what's here, because again, I want a good outcome I want the right outcome, I should say, for the parties that are involved. Hopefully we can find a way there in this regard. All right, so there's your notification. Go ahead to the breakout room. I'll be on the other side of that.
Okay.
Judge, this is David Bader. Can you also put us in the breakout room?
Excuse me. We're back to the regular on Palisade versus Natasha Johnson regarding the suffix 2619. Welcome back. Thank you for taking a moment to talk about this matter. Counsel.
Yes, Judge, we didn't have the opportunity yet. Can you put us in the breakout room?
Oh, that's right. That's right. Ms. Johnson was waiting. Thank you. I'm having you come back and you haven't gone in there yet. So let me,
No problem.
let me work that out. Right. Okay. And Mr. Goodman, you're back on the
Right Financial versus McGee/McCallum.
yeah, got it. That's the suffix 1176. Welcome back, welcome back, counsel, and welcome back, Ms. McCullough. All right, update Mr. Goodman, if you will.
Thank you, Judge. We're happy to advise the court that we've agreed to a payment plan of $100 per month starting December 31st. Starting the last day of each month, so November 30th. Is that right, Ms.?
No, it's December 31st.
All right, so December 31st, $100 a month for 12 months. And then we're going to reevaluate the payment plan after 12 months. Ms. McCallum has a pending workers' compensation matter going with her employer. And so she's not sure exactly when that's going to be resolved. And her attorney is telling her it could be 12 to 24 months. And so we're agreeing to this small $100 a month payment plan for 12 months, and then we'll reevaluate.
All right, that makes sense to you, Ms. McCollum?
Yes, sir.
All right, so I'm going to go ahead and set it up that way. I'll suspend the garnishment on the in regard to the Amazon fulfillment, although I know that you're not at work there. Setting this up and getting December 31st at $100 per month for 12 months with a review in after the 12-month period. I think you're going to do that review informally, or do you want the court to set a date for that?
If the court wants to give us a date right now, we can do that.
Yeah, I'll go ahead and set a date, a review date on this matter, and we'll.
Judge, I have a question.
Go ahead, ma'am. I'm listening to you.
Mr. Goodman, how do I go about giving you the payment?
Yeah, Ms. McGee, I will. You can. I'll give you that information. If you give me your email address, I'll email you the payment options.
Okay.
What is
It's
your
JENAMAGEE09@gmail.com.
Okay. Yeah, I'll email that to you. Okay.
Okay.
So the review date is going to be January 4, 2024. So just after, because you're going to do it for 12 months, and I'll just go ahead and set it in January of 2024. That will be on the payment order. I'm signing the payment order today and sending that out. And on the payment order, we'll have the next date of hearing at 9:30. January 4, 2024 at 9:30 a.m.
Thank you, Judge.
Thank you.
Thanks, Ms. McGee, or Ms.
Thank you.
McCollum.
And I wish you well, all the best to both of you, and to you, Mr. McGee, all the best to you.
Okay,
Thank you.
thank you.
What was that date, Judge?
1/4/24
Oh, 1/4/24 at 9:30.
at
Okay.
9:38.
Thanks.
And ma'am, I see you there, and I'm coming in just a moment to hear your case.
The case ended in 441. He had received consent judgment. I'm not sure.
Yeah, I signed that.
Oh, you did. Well, that was this one.
Yeah, right.
I'm talking about the one that's on the
That's correct.
docket. Nobody
So that's
showed up.
another one.
Nobody showed up.
What's the name?
The name? Unfund, UNIFUND. CCR
Yeah, I'm kind of twisted up. So
441. 441.
I don't have my. I misplaced that sheet that you had.
Oh, the docket.
Yeah, the docket sheet. Let me see your docket sheet. Point to which one.
It's the second one. It's the second one now.
Okay, then United Front,
Yes.
Unifront.
You.
Did I have it up here somewhere?
I don't know.
We'll take a look at that. Okay. These are the three orders. On this file. The hearing date is in. Just leave a copy there. If I could. So let me see your fact sheet.
And the printer don't work. I can't even print. I can't even print it.
Acceptance, right?
Hmm?
We had it found for the acceptance versus. I think they're registered.
Judge, I can't. print it. I mean, I can go somewhere else and come back.
Yeah.
Yeah, let me get it. Because I don't know why.
All right, so I'm back on the record regarding the suffix 6225. No, is that the one? Okay. I'm back on the record regarding the Palisade versus Natasha Johnson and the objections to writ of garnishment regarding that matter. Council will update you if you will regarding this matter.
Yes, Judge, we did make a offer to her. I gave her my best authority, which was a substantial discount. She countered it. I don't have any more authority, so I have to go back to my client And we would call her back within a day or two to see. I don't know if they'll go as low as she wants us to. I could tell the court the numbers if they want to hear it to show that we're acting.
Yeah, go ahead. Let's talk about it a little bit. Yep.
Okay, I told my authority is $10,000 by the end of the year, plus any money we get. We haven't gotten the last two payments, and she says she thinks she could come up with $1,000, but I don't have that authority.
She says she thinks she can come up with how much? I'm sorry.
Plus, yeah.
Plus what was already taken?
Plus there's two payments because we didn't receive them. Yes.
Okay. Wow. I mean, yeah, you're really close on trying to resolve this. I think that with the I think that with the interest rate and how much of this is about interest, I think that look, here's what I favor. You got 10 versus 8, 10 versus 7. So I say $8,000 and get this resolved. You can get it done by the end of the year. So the 8,000 would be inclusive of whatever's been taken by way of this garnishment, and then Ms. Johnson make up the difference. And I know you have to talk to your client. Ms. Johnson, would that seem to work out for you, ma'am? Ms. Johnson?
Here for
Would that seem to work out for you, what I just mentioned?
the last figure, were you saying 5,000 plus the 23 that was already taken?
I'm saying, yeah, I'm saying 5,000 plus the plus 3. So the 23, and then you have to add 7 to that. That's what I'm recommending. That's a little higher than where you are, and it's a bit lower than where they are. And there's a lot of interest here. We don't want to go back and forth too much on this because the law allows that interest, and that part is crazy. I mean, that's So I think that if you could get it to that number, I think that's a reasonable way to resolve it. Only because it's so many years that this is dragged, and because of the type of loan it was, you end up with this 13% interest, and that 13% just goes crazy over many years.
Judge, I mean, usually when a court tells us what they recommend, I do. I mean, no, I'm just telling you, we try to stay on good graces with the courts. And I mean, can we just do firm numbers that you release the garnishment money, which is the 2 checks, you grant that we get the 2 checks, which is, if I understood it right, it'd be it'd be 20.
It's a little over $2,300. I mean, I know that she wants to use that as leverage to try to get this resolved. That's what I understand here. And my inclination, I mean, you're going to get that released, but I think Ms. Johnson is trying to use that as leverage to get this resolved. So why don't I do this? Why don't I set it over a week, and let's see if we get this worked out in that period. I'll just adjourn it till next Wednesday, and I'll take another look at all of this. Okay?
Judge, out next Wednesday, unfortunately, because it's the day before.
You broke up a little bit, Mr. Bader.
I'm out next Wednesday. It's a holiday.
I can do it either Tuesday or Thursday next week as well. So, no, I can't do it Thursday. I can do it Tuesday. Next Thursday is Thanksgiving, right?
Right. I could do it Tuesday. What time?
Ms. Johnson, can you be back here with me on Tuesday, 9:30 or 10 o'clock, either one? Ms. Johnson? You broke up a little bit. That works for you, ma'am?
Yes.
Okay, 9:45 Tuesday. I'll review this matter. 9:45 Tuesday, and come back into the Zoom, and we'll deal with it at that time. Tuesday, that date is going to be the 22nd, November 22nd. All right, and we'll see you at that time. All right.
Okay. Thank you very much.
All right. Thank you, Ms. Johnson. We'll see you then.
Goodbye now.
To you, Mr. White, in just a moment. That's the one. And so we're back on the record regarding the suffix 6225 Automobile Club versus Washington and Campbell. And Mr. White has entered his appearance for Automobile Club of Michigan. Thank you, gentlemen. Mr. White, if you will update me at this time. Sir.
Well, it looks like the parties are willing to work together on this one. The terms are going to be that, and I don't know if you have that judgment we sent in there as a placeholder, Judge.
I do have it.
According to that judgment, it's damages of $5,998.86, costs and fees of $201.62 with a statutory attorney fee of $75. Total amounting $6,275.48. The defendants are agreeable to $150 payment every month starting the 15th of January 2023 in this case.
Mr. Washington, that I know we've talked about a whole lot here today, but that makes sense to you in terms of your approach at attacking this, that consent order, a judgment be entered on those terms with $150 being paid monthly starting in January 15th, sir.
Yes, sir.
Mr. Campbell, dad in this situation, the man in the same position as me. What have you to say on this, sir? You in agreement with approaching it this way, sir?
Yes, sir.
All right, I will sign the order then as a consent in this matter. The parties having consented on the record, and in the terms with regard to payment will be inserted in the document, indicating that commencing on January 15th of 2023, that a payment of $150 will be paid monthly on or about the 15th of the month from that date forward until the judgment has been satisfied. Anything else from either side?
No,
No, that's all.
All right, I do wish both sides well. Thank you for engaging in the discussion. That was important to do. And you'll receive a copy of the order that's been signed by the court in the mail in the next few days.
thank you.
All right.
All right, I wish you well.
You as well.
All right, this is case number 22195279. This is Credit Acceptance Corporation versus Dejanay Stinson. The matter is before the court. There was a previous pretrial scheduled in this matter. I don't have anything indicating that today is a. Okay, I see that. Pretrial schedule at 10 o'clock. 16. All right. Do I have anyone for credit acceptance on this Zoom? All right. And do I have a Stinson on this Zoom? Say something if you're there.
Yes, I'm here.
All right. Good morning to you, ma'am. Thank you for your patience this morning.
Good morning.
So it looks like, were you here before? Did you come before me on one other occasion?
No, that might have been my sister, Desiree Lindsay. She was my co-applicant.
Okay, got it. Got it. So I scheduled this for a pretrial, and I don't see where I issued a scheduling order regarding this case. All I have today is the cover sheet on this file. I don't have like further information. It looks like somebody is suing you guys for $10,000. What is this about? This is about a car or something?
Yes, it's about a car that I returned back. Well, I bought a car in 2017 from Car Source, and I voluntarily returned the vehicle at the end of 2019 due to me purchasing a cheaper car because the payments got too overbearing for me. And when I spoke with the representative from Credit Acceptance, she was telling me that I will be still responsible for the difference after for the remaining balance once they auctioned off the car.
Yeah.
Yeah.
That's kind of what it sounds like. Let me do this. I don't know when Mr. Barter is today. It's usually here.
My sister, she said that she made a payment plan with somebody over the phone just a few minutes ago. So I don't know if I'm just in the wrong meeting or or if she's in the wrong meeting.
Well, she was in another courtroom with this.
She's still in the courtroom actually.
Oh.
She
Okay.
just she's on the phone call though instead of the Zoom.
And it's regarding this case, right?
Yes.
Okay, she's probably gonna see me. I gotta go to another courtroom. That's probably what this case is about.
This should be in 5-4.
That should be 5-4. I'm going up there now. Okay, so if you want to, Ms. Stinson, you can zoom into 5-3-4 as well. I'm going to that court. I gotta cover that today.
Okay.
So this case is gonna come up there, 5-3-4. So
Okay.
the same way, 360, but in the middle you have 5-3-4, and then 0-0-0-0.
Okay.
I'll be
Okay.
up there.
Okay. Thank you.